Hi, and welcome back to Military Law Talks. I'm a former military lawyer with almost 15 years of government experience. And so today's video, I'm going to bust some myths. I'm going to dispel some information that you may think is accurate, but maybe isn't. And so today's video is about military retirement. Is it divisible in divorce? And what do you think? True, false? Is it divisible in divorce? Does it depend? What do you think? Put your thoughts in the comments below. And oh yeah, by the way, if you haven't subscribed, please subscribe and like this video, share this video with others. Unfortunately, in the military, the divorce rate is pretty high. So many of you may be watching this video or have friends that are going through a divorce. So make sure you share this video out there. And I have found actually a lot of attorneys don't even know the answers to the questions that I'm going to answer in today's video. So specifically, is military retirement divisible in divorce? The answer is yes. Yes, it is. Now, you may be thinking, well, I've heard something about like a 10-year rule. So, it's only divisible if you've been married for 10 years or longer. That's actually not true. So, according to the Uniformed Services Former Spouse Protection Act, military retirement is divisible in a divorce. Whether you live in a community property state like Arizona, California, or Texas, or in a state that uses equitable distribution, it is still considered a marital asset that can be divided in divorce. Either before retirement, the military service member is retirement eligible, or after they've already been collecting military retirement. And so there is a 10-year rule, but the 10-year rule only applies to who pays the military retirement. So let's give a hypothetical. So let's say we have a husband service member who has served in the military for over 20 years and is already retired and getting a retirement paycheck. And that service member is married, but unfortunately that marriage is not lasting, is not working out, and the parties plan on divorcing. If the parties have been married for over 10 years and those 10 years have overlapped military service by at least 10 years. So in my hypothetical, let's say that person had served 23 years in the military and has just retired in the last year, but had been married for, 18 years. And of those 18 years, sure enough, there had been at least 10 years of military service while that couple was married prior to that service member retiring. The spouse would meet that 10-year rule. That means if the spouse, the former spouse of the service member, is awarded any portion of the military retirement upon divorce, then DFAS would pay the military retirement directly to the spouse versus the retired service member having to pay that spouse every month. And so in order to do that, if you are the spouse or you're representing or the spouse who thinks that they qualify under this 10-year rule to get a direct payment from DFAS, they have to submit a form 2293 to DFAS and a court order directing that military retirement that is divisible. And in that court order, it does need to be specific. It needs to either list a specific dollar amount that is awarded to that former spouse or as a percentage of military pay. Now, even if the service member isn't retired yet, that still can be part of that final divorce decree, but then it just won't be payable yet until that service member retires. And maybe you've also heard of this 20-20-20 rule. So again, if there's over 20 years of service, the marriage lasted over 20 years, and there's at least 20 years of overlap of military service, that entitles that former spouse to even more rights. So not only do they get a direct payment from DFAS, if that military retirement if they were awarded a portion of that military retirement, but they are also eligible for an ID card to shop at the commissary and to shop at the PX. So they can still access the commissary and the PX at their local installation. But again, they're going to have to file that court order and meet those eligibility requirements. Now, if that former spouse remarries, those benefits will cease. Unless, of course, right, they remarry a service member and then they get those entitlements through that second marriage. But if that marriage is later results in a divorce or an annulment, those benefits can reconvene. And then there's also a 20-20-15 rule. So this is similar to the 2020 rule. So as long as there has been 20 years of marriage, 20 years of service, and at least 15 years of overlapping that marriage and that military service, the former spouse can actually still get TRICARE, still can get military medical benefits for at least 1 year after that divorce is final, if they meet the eligibility requirements and if they pay to continue that coverage for that year. So maybe you were thought of some of these myths. Maybe you believe that military retirement wasn't an eligible asset up for division and divorce. Maybe you're a service member who's thinking about divorce, and maybe you need to talk to your attorney and ensure that you get that your military retirement protected. And so hopefully you learned something today. If you did, leave a comment below, like this video, share it out there. And if you haven't subscribed, make sure you subscribe and hit the notification bell so you know when I post the next video. So thanks for hanging out, and I'll see you in the next